name's Pete. I live in mid-Wales, and about 3 years ago I started to challenge the council over council tax, and went through whole loads of things, notice of intention and all the affidavits and everything, because I claimed I didn't have a contract with them, like lots of people have done, and got pretty much nowhere with them. But what I've done is I've collected up a lot of the documents that I thought everybody might just be interested to see, and there's 2 or 3 documents in there that I don't think any of you have probably ever seen before. They're quite interesting, because what happened is, because I own my own house, I'm not a big landowner, it's a very modest little house, but I just happened to be lucky enough to be able to buy it. So instead of putting me in prison for non-payment, which they threatened to do, they decided to put a charge on my house, which has been sitting there for a couple of years. And so I've basically collected up loads and loads of documents that are all about the whole thing. And I've also looked into some of the underpinnings of how they actually run the prosecutions as well. So how they issue the summonses. So there's a few interesting documents that I've collected up. So after a couple of hearings where myself and a bunch of people, Guy Taylor came with me, we kept them going for about 2.5 hours on 2 occasions over liability orders. It was real great fun, but of course it didn't get us anywhere, but we learned a lot. So this first letter is a letter that I wrote to the court, because I just wanted to check a few things out. So this letter is a request to the court to send me the liability order that they'd issued. So it's just a very simple letter. I knew what the answer was going to be, so I sent them this letter, and they sent me a reply. Whilst the bundle containing the application for liability orders in regard to non-payment is held by the court, it is Powys County Council who will have issued the actual orders.
Wow.
So there it is, with straight from the court. There is the proof that the court doesn't issue the orders, the council prints them. And
so you read this, please?
yeah, it says this is an answer. This is the court's answer to my request for the liability order. Whilst the bundle containing the application for liability orders in regard of non-payment of council tax is held at Welshpool Magistrates Court, it is Powys County Council who will have issued the actual orders, which is what we've all known, but I actually got it on record and told me that, which I thought was... Okay, so this is a letter requesting that the council sends me the liability order. I'm not sure if we really need to see that one. This is an actual liability order. Lots of people get a printout with redactions from all the other people, but this is an actual order, an actual liability order which the council prints. And what it says is that a liability order was awarded against the above specified charge payer. It is adjudged that the taxpayer is liable, the charge payer is liable to pay the aggregate amounts listed below, and it is ordered that these amounts may be enforced in the manner mentioned in Part 6 of those regulations accordingly. And this here is exactly the same computerised signature that appeared on the summons. Carol J. Evans, that works in the Brecon County Court, who I've written to a couple of times. Now she's Justice Clerk. So that basically says the liability order was awarded, and there's a whole bunch of civil procedure rules of that awards, which I don't fully understand.
How much the cost of the charge bill?
The cost's 50.
50.
Yeah. I've got another piece of paper to show you about that as well. So can I shut this one? So this is an actual printed order, and as you can see, there's no court seal, and there's the same computer signature that appeared on the summons. This one here, because I've got my own house, And because they wanted to put a charge on my house, they had to go to the county court. Because as I understand it, it's only the county court that can say that you're a debtor. I don't think the magistrates' courts are allowed to brand you a debtor. So they have a whole process called conversion, where they convert a liability order into a county court judgment. And there is civil procedure rules that put that conversion process in place. Whether that's lawful or not, I really doubt. But the interesting thing about this order is that it's decided by somebody called proper officer. It's not a judge.
Is that a Mr. or Mrs. proper officer?
We don't know. It may be either. Now, I've been to the county court offices, and they say that all of the clerks in the office do this job. I asked one of them where she got her authorisation from, and she didn't know. She said it's just part of the job. But the reason why I took issue with them about it is because it's actually got a court seal on. I believe it's only a stamp. It's not a proper seal because it's not dated, and it has no signature on it either. So I phoned the office, and if we've got time, I can actually play a recording of the telephone conversation I had with the woman on the desk. But basically, what this is, it's an actual county court order issued by somebody that they refuse to name. It's not signed. It's only got a stamp on. And when I asked them why it was decided at a hearing that was held in secret, because they never tell you that this process is going on. Yeah. They said, oh well, it's just standard procedure. We do these all the time. And the interesting thing about it is it's not decided by a judge. And when I pressed them on why it wasn't decided by a judge, what she told me on the phone was, oh well, the decision has already been made in the tribunal, meaning the liability order hearing. And so I'm asking myself, if the magistrates' courts do not have the right to decide that you owe the money, that there's a true proved debt, then how can they then use the liability order as evidence to get a county court judgment which is a record of a proof of debt? So there's a very, very interesting question there, that what the magistrates' courts are actually doing is they are actually claiming that they're proving there's a debt when in fact they don't have the jurisdiction to do that. True. That's what I believe. But they then go on to use the liability order as evidence that you're a debtor. Because what this actually says is that the proper officer has considered the application, and the court orders that the applicant may enforce the award in this court, and the respondent pay the applicant's costs, etc. So this proper officer, who's not named, who isn't the judge, has decided on the basis of a liability order as evidence that I am a debtor. This is the first document in the process, and it's not heard by a judge. But what is heard by a judge? There you go. What is heard by a judge is the one who awarded this one. Now, the previous one was on the 30th of the month. So this one was on the 31st of May. The one that I just showed you, which the proper officer did, was on the 30th of May. So the proper officer did the conversion the one day in the office with no hearing. Didn't need to have a hearing because the tribunal had decided it. So hearing not necessary. That's what they told me. So the very next day, that document went in front of District Judge Morgan, who's considered the application of the claimant, the judgment creditor, and he's decided to issue an interim charging order on the property on the basis of the order that the proper officer issued the day before. So I then have another question: why didn't Judge Morgan do the conversion? Because I don't think he'd touch it with a barge pole. Because because it's fraud.
Yeah.
They're using a council printed liability order which didn't come from the magistrates, who didn't have the jurisdiction to say there was a debt proved anyway, and he's gone and rubber stamped the decisions made by people that didn't have the jurisdiction to make those decisions. So very interesting. So how do I get back to it? Oh, there you go. And that's a letter, that conversion letter is the county council explaining to me that they have the right to do the conversion. And then there was a whole load of letters that went back and forth explaining to me that they had the right to not inform me that the hearing was happening, etc., etc., which again is standard procedure. It's written in the Charging Order Act that they're allowed to have those first two hearings without informing the respondent. They only tell you about the final order, that you can go and defend that one, but not these first two. So this is the piece of paper. When we actually sat in court and watched them do this, they on this particular day, there's only a very small county, so there's only 731 orders granted that day. But this is a little slip of paper that sits on top of the stack of council applications in front of the magistrates. And the magistrate hears the solicitor speaking and said, "Oh, madam, we have 731 cases in front of you today." So the magistrate said, "Yes, okay, we'll allow all of those liability orders." And then he said, "Oh yes, and apply for costs as well." So she said, "Yeah, £50 cost for each case." And this is the slip of paper that, the only piece of paper that bears the magistrate's signature, this is actually it. And I got this through a very roundabout way. The council nor the court gave them to me. It actually came from the boss of the bailiff company. That he sent me this just as evidence, but what he didn't realise was he was giving us all a bit of a gift, because we've all heard about this process. But this is the actual piece of paper, and Mrs. Somebody Jones, as Justice of the Peace, has signed it. So she signed a piece of paper. This was about 5 minutes' work for the solicitor. She signed a piece of paper giving them the rights to send bailiffs around to 731 people's houses and charge each of them £50 costs. And we reckon 731 times 50 quid ain't bad for a morning's work.
It wasn't Jones, it was Capone, I think.
Capone, that's right. Yeah. Yeah. So, I thought you might like to see that, because we've all heard about this document, but I don't think many people have seen one. Yeah, this is a bit that I really wanted to present, because all of that's kind of building up to this in a way. These are extracts from Stone's Justice's Manual, which I suppose a lot of people are familiar with. It's those 3 blue books.
I'll open it.
So these are extracts from Stone's Justice's Manual, and what these are is Stone's Justice's Manual is the manual that the clerks of the courts use to run magistrates' courts hearings, and everything that they need to do and know is laid out in there, apart from all the law they need to know as well. So this is the bit about starting a prosecution in a magistrate's court, and this is just a small extract. It's the instructions that the clerk or the justice needs to follow in order to issue a summons. I'm in a lot of trouble with this. And in the criminal proceedings in the magistrate's court, when somebody lays an information or makes a complaint, the justice or the justice clerk must apply his mind to the information and go through the judicial exercise of deciding whether or not a summons or warrant ought to be issued by him. His initial concern will be to see that the information discloses an offence known to law. That's in the criminal. But because council tax isn't a criminal offence, non-payment, there's no criminal offence of non-payment of council tax. The whole thing is completely civil. So then I decided to have a look at what the civil one said. This is actually very interesting. civil proceedings in magistrates' courts, after a complaint is made, a justice or a justice's clerk must apply his mind to the complaint and go through the judicial exercise of deciding, etc. Its initial concern will be to see that the court will have prima facie power to make the order asked for. So, if that is what the justice's clerk needs to ascertain in order to issue the summons, how come they're issuing summonses that the court doesn't issue an order for? So the question is, does the court actually have prima facie power to issue a liability order? Yeah.
Court never sees them.
Pardon?
Court never sees them.
Never sees what?
Liability order.
No, I know, but this is the instructions given
Yeah.
to the justice's clerk in order to decide whether to issue a summons. So, if the justice's clerks know that the court doesn't have jurisdiction to issue liability orders, and what we know is that they don't issue them, then does the magistrates' court actually have the prima facie power to issue a liability order? And if they don't, then the case should never be in the magistrates' court. It actually should go straight to the county court. So I find that very, very interesting. I've never ever found anybody that knows whether the court really does have the prima facie power to issue those orders.
Sorry, can I just ask you what prima facie means?
It means on the face of it.
On the face of it?
Yeah, just first. But it doesn't really matter. Does the court have the power to make the order that's being applied for? Because the council's applying for a liability order. So does the magistrates' court have the power to decide whether you are the liable person even, let alone whether you owe money?
Well, it says there we can do after a complaint is made within 6 months of the offence was committed.
That's an offence that we're talking about the matter of complaint, the bottom one. But that is that the point? The question is, does
so
the
what's
court...
the offence? The offence is non-payment?
No, there isn't any offence. The offence would be something criminal or something that they call an offence, but this is the bit. It's the matter of complaint. Because they're complaining that you haven't paid. So I don't think they're saying it's an offence, but what they are saying is that the magistrates' courts somehow have the power to do something. But what they sure as eggs don't do is they never ever issue an order. It's always the councils that issue the order. So I wonder whether the magistrates' courts actually have any power over the matter at all. Pardon? Sorry. Oh, great, great. I just thought I'd get this put out so that people know what the Justice's Manual actually tells them they should be doing, because it's all in their own writing. Yeah.
That's why they don't issue them, because they haven't got the power.
No, they don't have that. I don't believe they have the power.
So who gives the council the power to issue it?
Pardon?
Who gives the council the power to issue it?
They don't, because they're not a court. It's complete fraud.
So nobody's got any power to
Total
issue a
fraud.
liability order.
But the reason why I decided to point this out is that it helps us to understand how the magistrates' courts and the whole process is defrauding us. Because it's my belief that the Justice's clerk is breaking the law by issuing the summons.
Yeah.
That's the important bit, and we can nail them for it.
Yeah.
If we can get it right. What we need to be able to do is to prove that the Justice's clerks know that the courts cannot issue that order.
You give a little bit about it, please, guys.
The point has come out that it's my belief that the Justice's clerks are breaking the law when they put their signature to the issuance of the summons, because they know that the courts don't have the prima facie power to issue the order asked for.
Yeah.
That's the, and so so we can all go out and start holding our justices' clerks to account.
I think the issue is because the council's applying that justice clerk's facsimile signature.
Yeah.
Apparently this is all okay.
Yeah, that's right.
That's acting under the bond of the justice clerk. Even though it's an assistant justice clerk, it's still acting under the bond of the justice clerk. There has to be a written agreement between that justice clerk and whoever it is allowed to use his or her signature.
That's right.
We need copies of those agreements, and at the moment I'm being stopped. They will not provide. They are terrified. They will not let us have information.
Because
That agreement will allow the parameters of what he's allowed them to do, and that in itself would stand as evidence of fraud.
yeah, I bet you there is
And
no
that is the
agreement.
key. Yeah, well, yeah.
Because as Mr. Ebert is constantly saying, they have become accustomed to this culture, and what we need to do is to break that culture.
Yeah.
Because for them, this is just normal.
Yeah.
So where does this all come from? Is
What,
it, no,
this?
no, sorry. Where does it all come from, this culture? Is it the people that have had the jobs that have just, oh, do this, and then
Yeah,
everything
that's
is
right.
sort of just escalated?
I think so, yeah.
Yeah.
Yeah, and of course it's all corporate. So if they can cut corners and get minions to do all of the things that proper judicial people should be doing, then they'll do it.
But just
It's
again,
cheaper.
just to follow it up, we managed to get hold of a document 18 months ago, which we released, and it was from the Justice Clerk Society, and it was guidance notes for justice clerks, how to do this, how to create liability orders, and it was telling them the steps how to do it. The Justice Clerk Society is a private company. What the hell is a private company doing, getting involved in judicial process and inventing new procedures? We went public with that at 10 o'clock in the morning. The Justice Clerk Society folded and closed its doors at 4 o'clock afternoon. People don't know we do get results, you know. They're usually they're reborn again now. But we did find out that there's more directors through the front door of that, in and out the front door of that Justice Clerk Society than there is on a Saturday afternoon in Asda. What were they seeing when they were in there that made them want to leave so quickly? There's such a flurry of directors leaving, all joining and leaving. What were they seeing? This is what they're seeing: fraud.
Can I just mention that last year when I got my summons to go to court for non-payment of council tax, there was a photocopied signature at the bottom of it, and it was just a scribble.
Yeah.
And I think it was Mike that investigated as to who this person was, clerk of the court. And Mike traced him back to, he was a barrister, or a barrister in London.
Really?
Yeah, and he'd been there for, was it 6 years, Mike?
Yeah, I actually spoke to him, and he said I've not been to Warrington for about 6 years, and he's the
This
Justice
is the
of
guy
the Clerk.
that's signing all the
It was in
summons.
prison for the period.
They're still using his signature, and he was used to be the clerk of the court from Chester,
Yeah.
and they were in Warrington, they're using his signature.
Yeah.
And he's
Still
been
using
in,
Chester.
been in London for 6 years.
Is he getting paid? Is he getting paid for signatures?
Probably.
Yeah.
That's what they're asking for.
Did he know, Mike? Did he know his signature was being used?
Oh yeah, yeah.
He didn't know it was being paid then.
Some of them used to be called designated officers. It's probably just a clerk in the office. I think they just do anything because the culture says, oh, we just do it, and it all goes out and nothing ever happens.
Yeah.
We just do it.
Well, there's no redress for them, is
No,
there?
no,
There's
no.
nobody to redress them.
Well, except us.
Well, there is. This is the assistant clerks who need an authority to use his signature. And these are what the gentleman is saying. They've got no authority to use the actual person's signature.
But they have. They've got it in Rule 3 of the Clerks of the Justice's Rules 2005.
Is that right?
Yeah, which basically allows it to be a delegated authority.
Yeah.
So basically it's just like, it's a free-for-all.
Yeah.
You know, the problem is that they're getting away with it and they know that the people don't know how
Yeah.
to bring it against them.
Yeah.
It's just like someone will keep robbing your wallet out of your pocket unless you do something about it.
That's right.
Every day, you know, at school, if you like the kid that's getting bullied for his dinner money, he's just going to keep getting it until he fights back.
Yeah.
And parliaments are passing all these rules and legislation. There's no judicial oversight into any of what's going on. And, you know, you can't even find who it is who's written, because I'm the same. I've got summonses from Keith Tarman, the Clerk of Justice.
That's the guy.
And on the same day, I've had one from Chester, Liverpool, Warrington, from different cases. It's like, how can you be in all these places at one time? And it's impossible, which means there's no scrutiny. It's just like an electronic fax mail signature being cut and pasted, and then they're saying that's all right.
Yeah.
But there is remedy and there is redress.
Yeah.
And for you as well, with what you said before,
Yeah.
there's remedy and redress. And when you talk about conversion, they're using conversion against you. You've got to turn the tables and use it against them.
That's right.
Because what they're doing is they're converting your property for their use, for their financial gain.
Yes.
They have to establish that they've got that authority. You have to basically take the claim against them so that they can evidence and prove, because you make the allegation you didn't have the authority and basically put in the law to support it.
Yeah.
And then they've got to come back to you and say, well, we did have the authority, it was done on this day. And then the orders have got to comply with the civil procedure rules or the criminal procedure rules. It depends what one you're going on.
Yeah.
Now that section 127 that you add up about the judicial scrutiny, that doesn't apply into the liability orders. There's no 6-month time limit on the issuing of a liability order.
No.
You've got 6 years for that. Section 127 is disapplied in
Yeah.
council tax matters.
Yeah.
So
Can I just ask you a question? If this guy's signature is being used all over the place, could we use it? Could we write our
no,
own?
it's fraud. You know, there's no. It's fraud. But the thing is someone's put a rule book in that says they can do it. What you've got to do is find a rule that says they can't do it, because it's complete mockery of what the law is supposed to be. Because it's supposed to go through judicial functions, and it isn't.
Well, the point I'm trying to make is that if anybody can use that signature, which they're sort of saying, any court, any magistrate's court, anywhere in the northwest or anywhere in the country can use that signature, can we not print our own out, just like bailiffs companies do, and use his signature?
Well, you know, the thing is yeah, I've thought of doing that many a time, and putting a summons out to them and putting the name on it. The thing is it's a delegated authority that you then get in trouble for, because they say you didn't have that delegated authority.
Yeah, but they're not being able to, they can't prove that they've got it.
Yeah, but they're part of the club.
They can prove it, because if you take a claim against them, they'll support each other. All you've got, see, the only hope you can hope for in that is to point out that the way that they're bringing the system out, they brought it out and used reasoning in Parliament to say that, well, it costs a lot of money, so even though it's an administrative task, the issuing of the summons, it's not a judicial function. The judicial function happens when you're presented before the court. So that's basically when they fix the administrative tax that's gone on and the information is read out to the court. That then classes as well the judicial functions being completed.
Yeah.
So to them it's happy days, because it saves them a lot of money. Whereas once, if you're exposed that system is failing miserably and affecting lives and that can be put out, then that's when you may well get back the judicial scrutiny, because it clearly doesn't work. It clearly is being, you know, you must have 100 people a day copying that signature and pasting it to tablets, going out all over the country.
It's about 400, I think.
People have, you know, maybe 400, maybe a couple of thousand, you never know. The amount of sums that are going out, but the only way is to take the claims against them and get them to present. You can't ask them for information, because they're not going to supply it to you. They'll just supply you a load of bones.
Yeah. So I've got a couple of miscellaneous things that kind of fit in with this that might be nice to just have a look at. Form N323. Has anybody ever heard of that? This comes off the Westlaw site.
Oh yeah, we've all had one of them.
Well, what's really interesting about this is when the bailiffs came round my house, they gave me a notice, which was a notice of execution of a distress warrant. So I wrote to the boss of wrote to the bailiff company, and I had a letter back off the boss. And what I asked him for was a copy of the warrant, because their notice said they were executing a distress warrant. So I wanted to see the actual distress warrant. And he told me in the letter that the distress warrant is an instruction from the council. Well, but actually it's not. A distress warrant is a piece of paper.
It's a signal.
Yeah.
I've been told it's a signal.
Right. Okay.
They send a signal to the bailiff company to do whatever they ask them to do.
So the nearest I've got to what ought to happen if they did get a warrant, a proper one, is that they would have to fill out one of these forms and present it to the court. It's a request for warrant of execution. And what's interesting about it is that just here, it appears to be asking for the claim number that the county court judgment was based on, that you're actually a debtor. But they never take these these cases to the county court. Only when they want to put a charge on somebody's house or make them bankrupt or whatever it is that they do. That's the only time that any of these cases would go anywhere near a county court. So my bet is that every single bailiff that goes around harassing people for non-payment of council tax, and probably parking tickets as well, has never ever filled out one of these forms. And they can't, because it's never been to the county court.
Correct.
Yeah? So what everybody needs to know is that none of those bailiffs have a warrant. If they did, I'd be really surprised. Because they've never ever gone to the trouble to get a county court judgment which would make it possible for them to make this request. So just log it into the brain cells that this process doesn't happen. So the easiest way to get rid of them, really, I've found, is to just insist that they give you the warrant, and they haven't got one. And they can't.
Can I just show you that?
Yeah.
We asked for a copy of it, of the original distress warrant,
Oh, right.
and that is what the court sent us.
Oh, wow.
They say that they sent that to Marston's. And if you look at it, they came on the 4th of February this year, but if you look at the date when that, on that actual copy, because it says copy,
Yeah.
if you look at the date on it halfway down, it says the 23rd of
23rd of December, yeah.
But what's the year?
2014.
It's not actually,
I tell you what.
that distress warrant is not actually live yet.
Right. Be written in 2014 and backdated.
Yeah. I tell you what.
Tom Cruise wrote that.
Okay. I will lay money.
Doctor Who.
I will lay money that this didn't come from a court.
It
And
did.
right.
It came from Burnley Magistrates Court.
Well, I'll tell you what, when Guy gives his talk later on today, he's going to be talking a lot about these documents, because virtually every one of them is a forgery or a fraud of some sort.
Well, is that no?
Yeah, got to be. Yeah,
But it's
there
actually
is.
stamped on it that that is an actual copy. As you can hold it up and show it. It says copy, stamped on it.
It does.
twice.
It says copy, and it hasn't got court seal on it. And I don't think that that is a genuine crest either. It doesn't look right. Because we have started to gather some evidence that the solicitors' offices are issuing these, and they've got court stamps.
At home, they've got them at home with embossing at home, I've seen.
Have you?
Yeah.
Wow.
Take
Well,
it.
Guy's going to be talking a bit more about this. We've seen that recently. We've seen at least 3 writs of possession where people have been evicted, where the documents are most definitely forgeries, and we think it's widespread.
I think you're right.
Yeah. And what's interesting is that very often the courts can't authenticate these because they didn't issue them.
That's correct.
So the authentication of fraudulent documents is getting to be a very, very hot topic, because I don't think they can authenticate any of them. I'm not even sure they can authenticate a genuine one. I mean, there's no barcode on them, nothing. How could they be related to a database? I don't think they could be. Interesting. I think that's most of the miscellany that I've got to present.
Sorry, could I ask, I know I was out of time, but could I ask to see the liability order again?
Yeah. Yeah, would you like to? Or can I do it?
Yeah.
It'll cost you £50 on that.
That's,
Is that a real liability order?
yeah. Well, real is one of them, because this is actually printed by the council.
We've got a letter to say
I
that.
can do that.
Yeah, that's good. That's good. Any of us could do one of them at work.
All right, guys, keep those down, please.
Yeah, that's what the council sent me. But did you see the letters that preceded it?
No, she didn't.
Oh, right. I wrote to the court to ask for a copy of the liability order, and I knew what the answer was going to be. They sent me a letter back saying it would be the council that will have issued the order. So then I wrote to the council, and that's what they sent me. And I'm one of the lucky ones. Most people just get a computer printout with all of the names that don't apply, that aren't yours, tip-X'd out, and they just leave yours. But this is an actual, what you might call a proper one. But it's issued by the council. And if you scroll down a bit, that's the computer signature there, and it's the same signature that's on the summons.
Something worth pointing out, if there's any document that's produced officially or formally, must have a document number to be part of a quality assurance process.
Yeah.
If there's no document number on it, it's not part of a quality assurance
No,
process.
the only number on it is my account number.
Yeah, it's not a document number.
There. That's the only, as far as I can see, it's the only number on it. So that's what the council sends you if they can bother to print one. But very often they just photocopy one page of their massive great printout and tip-X out the names that aren't yours. I know several people have got them.
Yeah.
I mean, with council tax, you can go from the beginning to the end, and the whole thing is just done.
The complete thing is
Because
full.
A, they haven't even got any authority over you anyway.
Yeah.
That's right.
Because you're not in a contract with them.
Yeah.
You know, and there's no legislation that says you have to pay.
That's
and then
right.
you're just coerced into it, and
Yeah.
then it just gets worse as it progresses.
Yeah.
And until they send the wolves to the door, and even
That's right.
now taking cars and things.
Yeah.
And it's the whole system is
Yeah.
just
That's right.
crap.
And they're a corporation anyway. They're not allowed to impose tax anyway.